So this is the third video in my series on formalities and constitution, and today I'm going to be looking at the very important principle from the case of Milroy and Lord. And then I'm going to be working on the fourth and fifth videos, in which I'm going to be looking at the exceptions to the rule that we're going to look at today. And then finally I'm going to take you through a couple of examples to show you how it all fits together. Before we begin to look at the case, there's just a couple of points that I want to talk to you about. The first one is just a very basic overview. So as a property law student facing a problem on formalities and constitution, you'll often be required to work out what the relevant rule is in order to advise a property owner on how to achieve what they want to achieve. Or probably more likely is that you'll have a scenario where you're told what a property owner has done and you need to work out the consequences of those actions. So in constitution, you'll be looking at whether the property owner achieved what they intended to achieve or not. Another point I want to quickly mention, which you need to appreciate if you're advising in a situation where the property owner has died, that you can only give away your property that you own beneficially when you die in your will. So any property that you give away before you die doesn't pass under your will, and this includes putting property into a trust before you die. So if you dispose of property during your lifetime, so if you give it away or if you sell it or destroy it, then it can't pass under your will to the beneficiaries of your estate. And just to stress, if you're holding property on trust for somebody else, then you're not the beneficial owner of that property. So it isn't part of your estate when you die or if you become bankrupt. Here's a reminder of what we saw in the last video when we looked at what we mean by constitution. So when making a voluntary disposition of property, the legal requirements to transfer the property must be complied with. And so it's about voluntary dispositions, so it's gratuitous dispositions. So we're dealing with gifts here, so we're not looking at a situation where there's a contract. And again, just another quick recap from video 1. Why does all this matter? Well, the usual scenario you'll be asked to advise on in an assessment or to discuss in a seminar is that the property owner has attempted to dispose of an item of property they own by making a gift, and then he or she either dies or becomes bankrupt or simply changes their mind, and you have to decide whether the property passes under the terms of the will, or if the trustee in bankruptcy can use the property to pay off the bankrupt's creditors, or simply in the case where the property owner has changed their mind, who is entitled to the property. So what you're looking for is who is the beneficial owner of the property, and if the property owner successfully transferred his or her ownership, then they were no longer the beneficial owner. So if they successfully set up a trust of the property, then the property owner is no longer the beneficial owner, and when the property owner dies, the property doesn't form part of his estate, so it won't go to the beneficiaries of his will. Now let's look at the important case of Milroy and Lord. And here's what happened in the case. I would normally encourage you to read as many of the cases as you possibly can, but in this instance the facts are quite complicated, so I wouldn't advise that you try to read the case in full. So the property owner, the settlor, intended to set up a trust for his niece, but unfortunately he used the incorrect formalities to transfer the intended trust property, and the uncle, the settlor, then died. So the niece, the intended beneficiary, was a volunteer. She hadn't provided any consideration. The trust wasn't constituted before the settlor died, and therefore we have a situation where we have an imperfect gift. And the issue was who was entitled to the shares. Could the niece claim that she should be entitled to the shares, or did they form part of her uncle's estate and go to the beneficiaries of his will? Now, in the case, Lord Justice Turner identified 3 different methods of making voluntary dispositions, and he called them the different modes, which is the terminology I'm going to use as well. And you may recognise these as I introduce them to you in video 2 in this series of lectures. So you can either make an outright gift, you can transfer the property into a trust, or you can declare yourself to be a trustee. And this is the principle that we can distill from the case. The property owner must do everything necessary in order to transfer the property. So the property owner must comply with all the relevant formalities to transfer that type of property. Now, if the property owner does do everything necessary, the gift is perfected, as we would say. So if a property owner is making an outright gift to you, then you become the new owner and it belongs to you absolutely and beneficially. And if it's a trust, the trustees now hold the property on trust for you, and the court will enable you to enforce your rights in the property against the trustees and sometimes against third parties as well. And this is despite the fact that you haven't provided any consideration for the disposition. But what happens if the property owner doesn't transfer the property? In that situation, you have an imperfect gift. And this is what Lord Justice Turner said. If the voluntary disposition is intended to be effectuated by one of the modes to which I've referred, the court will not give effect to it by applying another of those modes. So equity won't step in and help the volunteer beneficiary if it's a trust, or a donee if it's an outright gift. Essentially, the court is mistrustful of gifts. If the beneficiary or the donee hasn't given anything in return, then the court wants to make absolutely sure that the property owner actually wanted to complete the gift. So continuing on, here's what Lord Justice Turner says. If it is intended to take effect by transfer, the court will not hold the intended transfer to operate as a declaration of trust. So what does he mean by that? And essentially what Lord Justice Turner is saying here is that if you use one mode and get it wrong, the court won't substitute a different mode to give effect to your gift. So let's just see how that could work, and here's a reminder of what we saw in the last video. So a property owner is declaring that he's holding his shares in BSL Limited on trust for his children, and what we now know is that is mode 3. So this example is taken from the last video. And again, as we saw in the last video, there's no need to transfer the trust property because the property owner, the settlor, already has legal title to the property. So you could say that the trust is already constituted. So to reiterate, where the settlor is the trustee, there's nothing for him to do to constitute this trust. He does, however, of course, have to declare the trust. The trust doesn't just materialise from nowhere. But if the trust property is personalty, he can declare the trust, as this settlor has done here, by simply stating that from now on he's holding his shares on trust. And as it's a trust of personalty, it's not land, he can do this orally. So, if, for example, the father of the bride stands up at the wedding reception and says in front of all the family members and all the friends that he's making a wedding gift to the happy couple by saying that he's holding his shares in the family company on trust for them, that's it, the trust becomes effective. Job done. Imagine the same scenario. The father of the bride declares a trust of his shares, but this time it's a trust by transfer to trustees, so it's mode 2. The declaration of trust is perfectly valid, but before the father has time to complete a share transfer form to constitute this trust and transfer it to the trustees, he suffers a fatal heart attack. So he hadn't done everything necessary to transfer title to the trust property to the trustees before he died. Now, in that situation, it would be tempting for the beneficiaries to argue, why can't the court simply substitute mode 3 instead? That gets around the problem of this imperfect gift of shares. It would solve the problem that the trust wasn't constituted. But unfortunately for the intended beneficiaries, Milroy and Lord states that you cannot do this. You can't substitute the intended mode for a different mode. So you can't substitute the intended mode 2, as it is in this case, for mode 3. Equity will not help the volunteer couple. It won't perfect the gift by substituting the intended mode, which required a transfer of title, with mode 3. So the core meaning of equity will not perfect an imperfect gift is that the court will not substitute a trust for a failed transfer. So you can't substitute mode 3 for mode 1 or mode 2. So in other words, the property owner must get it right and constitute the gift. So for each voluntary disposition that you're looking at in a question, you need to identify the intended mode. So look at the wording, and usually it will be fairly straightforward. So here's just some examples for you. I'm giving you all my shares in BSL Limited, do what you like with them. That would be evidence of an intention to make an outright gift. The second one, I'm setting up a trust of my shares in BSL Limited. Tony and Tamsin will hold the shares on trust for you until you're 25. In that case, the intention is to use mode 2. The settlor wants to set up a trust by transfer. Here's something for you to consider when you're looking at a question on formalities and constitution, and you run through the 3 certainties very quickly. So you check that the certainty of subject matter and certainty of objects, and usually they will be very, very clear in a question that's essentially on constitution. And what I do is I deal with certainty of intention last. So I look at subject matter and objects, and then I deal with certainty of intention, at which point I would distinguish very clearly between a trust by transfer to trustees and a trust where the property owner is declaring himself a trustee. And if you do it in that order, it does avoid some repetition, and I think it helps the answer just flow a bit better. And then you need to see whether the gift was perfected or not. And if not, then advise the beneficiary that prima facie equity will not assist them by giving them a remedy. And of course it's a gift, so they can't sue for breach of contract. As I mentioned at the beginning of the video, I am a private tutor in property law, so if you are interested in private tuition, please feel free to contact me. My details are on the slide there. I would also really appreciate it if you would subscribe to my channel or like or share my videos, as it really does make a difference. I am new to this, so it will give me an incentive to carry on. Please also feel free to write comments in the box about the video. I can't enter into a personal correspondence about your particular assessment question in this way, but if you have any comments to make about the content of this video, I'd be delighted to hear from you. So now we've looked at the principle in Milroy and Lord, let's see how we can put that all together. And on this slide, I've just set out a common theme to problem questions on formalities and constitution. I will be going through an example with you in the final video, but here is how an answer to a question involving constitution would normally unfold. So you need to explain the relevant law and apply it, and then conclude whether the gift was perfect or not. Now, if the gift is imperfect, you would need to explain that the court won't substitute mode 3 for the intended mode. And so you would conclude that prima facie the court would not perfect this gift. But as we'll see in the next video, this can only be an interim conclusion because the case law has developed post Milroy and Lord, and there are various exceptions to this rule which might apply, and I'm going to be having a look at some of the most important exceptions in the next video. So thank you so much for watching. I hope that you found this video helpful. I do also post on the student room in the Law Study Forum occasionally, so if you want to have a look at some of the things that I've been involved in that chat room, then please head over to that website. My username is Bitesize Law, and more recently I'm Law School Hack. You can tell it's me by the watermelon logo. And in my next video I'm going to be looking at the developments since Milroy and Lord. Thank you again for watching. Good luck with your studies.